an additional affidavit, Your Lordship, in connection with item number 38, Your Lordship. My prayer for tag with the record, Your Lordship.
Yes, it can be called.
May prayer, Lordship, bail application, Lordship, for listing on tomorrow, Lordship.
What matter?
In distributed bill.
It is for more. This
Motion,
court,
Lordship.
this court can take up that matter.
Yes, above 7 years.
May I please, Your Lordship? Lordship, I am praying for listing of an interlocutory application, my lord, for modification of order. My lord, petitioner name is Saiful Islam.
When you want,
Today, my lord,
not today.
and tomorrow, my lord.
May I please, Your Lordship? I beg to mention for listing a AP matter, Lordship, tomorrow, Lordship.
When have you filed?
Lordship, yes, today, yesterday, Lordship. Lordship, oblige.
May I please, Your Lordship? I am praying for the listing, Lordship, criminal petition, Lord.
Listing
14.
criminal petition, you have to pray before registering.
May I please, Lordship, I beg to mention item number 46 with the consent of other side. Atogada matter.
Mr.
C. Talukdar.
C. Talukdar Learned Counsel for the petitioner who prays for an adjournment. He submits that he has obtained the consent of Learned Counsel for the
Lordship,
Con-
kindly maybe 15 November.
considering the submissions made by Learned Counsel, the prayer is allowed. Let this matter be listed again on 15th of March.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention for listing a bail application for tomorrow, Lord.
When have you filed?
Today, Lordship.
Let it come up in, or it will otherwise come up day after tomorrow.
Lordship, Tuesday, Lordship.
Okay.
Lordship, I beg to mention item number 25 of daily list. Lordship, in this matter, CD has not received.
Item number 121. 25 minutes is there in office.
Heard Mr.
You Ghosh, Lord.
U. Ghosh.
Interim is there, Lordship.
Also heard Mr. P. Thakur, Learned Additional Public Prosecutor, who prays for some more time to produce the case.
On my lord, 8-12 minutes.
Prayer is allowed. Let this case be again fixed on 8th of December. The interim order shall continue.
Deeply obliged, Lord.
May it please, Your Lordship? I beg to mention item number 27 of the daily list. Perhaps CD is not available, Lordship. I'm on interim, Your Lordship.
Heard Mr. P. Thakur, Learned Additional Public Prosecutor, who submits that the case diary has not arrived and prays for some more time for producing the same. The prayer is allowed.
On 7-12 minutes.
Prayer is allowed. Also heard Mr.
S.A. Borbuya.
S.A. Bodhmaya Learned Counsel for the petitioner. Let this matter be listed again on 7th of December 2023. The interim order shall continue till its day.
Deeply obliged.
May I please, Your Lordship? I beg to mention item number 24. My senior counsel, due to personal difficulties, only able to come today. Kindly-
Miss
Miss Tasniba Begum.
Well, in this case, already charge sheet submitted.
charge sheet has been let you go and pray before the trial court. Heard Miss T. Begum, Learned Counsel for the
Item number 24.
petitioner. Also heard Mr. P. Thakur, Learned Additional Public Prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid in this case. By charge sheet number
CS number 147/23 dated 37/23.
in view of the submission of the charge sheet, this anticipatory bail application is disposed of. It's an observation that the petitioner may approach the trial court and pay for regular bail before Learned trial court if so.
Your Lordship, I beg to mention item number 37. Kindly the matter may be adjourned for today.
37 my lord, case diary received.
Heard Miss,
P. Bora.
You-
Bora.
on what ground you are seeking it?
My senior is not available. He has some family urgencies.
Heard Ms. P. Bora, learned counsel for the petitioner who prays for an adjournment due to personal difficulty of conducting counsel. On the other hand, learned additional public prosecutor submits that the case diary has arrived.
Yes, sir.
The considering the grounds mentioned by the petitioner's counsel, the prayer is allowed. Let this matter be listed again on. When can we pick it?
Detailing. On my lord, not a, on 14 minute, 14:11,
Not 40,
14, then on my lord, 17:11.
17:11. The case diary may be retained till that.
Much of that.
May it please your lordship. Lordship, we have filed one criminal petition on 6/11, lordship. It has not been listed yet, lordship. We have challenged the 133 proceeding.
You pray before registry, but why it has not been?
Lordship, unless your lordship allows my mention, lordship, tomorrow it will not be listed and Monday is a holiday, lordship. In 133 proceeding, my bamboo fencing has been
No, I
directed
mean,
to
I
be
expect
removed from the path, lordship. And in fact, that is my purchase
Okay.
land and they have already instituted a civil suit, no injunction petition was filed for urgency. Oblige.
24, 14.
My lord, my lord, I would like to, she has wrongly mentioned item number 24, my lord. Because my lord, now she stated that she has to mention item number 42, but my lord, she has mentioned item 24.
I'm here for
And you have to be careful. 24, item number 24. Cancel that. Item number 42, on request of learned counsel for the petitioner. This case is adjourned for.
Lordship, date may be fixed, lordship. I'm for a respondent CBI. 20.
Just a minute,
Lordship.
wait, let me. Wait, item number 42.
42 and 43.
Forty-two is a hearing method. And who is in 43?
CBI.
Have you informed the council for who is appearing in 43?
42, I have no idea.
You have to find out Mr. H. Dekha, because it is tagged matter. Otherwise you don't have an objection.
No, that's not.
Heard Miss, what is your name?
Taslima Begum.
Heard Miss T. Begum, who prays for an adjournment on the ground of personal difficulty of her senior learned counsel for the petitioner. He submits that she will inform the counsel for learned counsel for the petitioner of criminal appeal number 175/205, which is tagged with the instant case. Also heard Miss
Tasnina Begum, T Begum.
T.
lordship.
Begum, appearing for learned,
I'm for CBI, lordship, Mr. M. Hallo, special PP CBI.
appearing for Mr. M. Haloy, special public prosecutor, CPI, who does not oppose the prayer for adjournment. Hence, the prayer is allowed. Let this case be fixed again on
23, lordship.
23/11.
Okay.
You have to inform the council to find out who is the council for Ms. H. Taken.
May I please, your lordship. My lord, the appeal is pending, my lord, since 1.5 years. And I have filed the IA, my lord. In IA, my lord, the order has passed their IA and the main case will be taken together, my lord. So this appeal will come up on 14, my lord, if possible.
No, it is not listed.
No,
Your prayer for listing,
yes, ma'am.
this you have to make. You have to approach registry for listing of an appeal.
Pending matter, my lord.
No, all matters are pending.
In IA also not pass the order.
No, what I understand that your appeal is of which year?
Well, the appeal of 2022.
You have not filed any petition for expeditious hearing.
But the last occasion order was passed and matter was listed for hearing also and subsequently not listing.
So first you have to approach registry. Because there may be other cases in queue. If you have to jump queue, then you have to file an interlocutory application praying for expeditious hearing.
May I please, your lordship? Lordship, in item 12, we have filed wakalatnama to the on behalf of the informant. Lordship, that may kindly be brought into record
Okay. Wakalat.
in item 12.
Item number 24, we have inquired, charge sheet has been submitted. Petitioner is on interim. My lord.
Earlier, my lord,
We cancel in 24, we have dictated an order.
yes,
In which we have cancelled. Only change the name of counsel. Instead of T Begum, what is your name?
Care of Mandat.
Mention. You approach before London trial court.
Lordship, my lord, session tribal section is there, my lord. May I pray for, my lord, till commit, maybe, my lord, extend it. Or, my lord, it may,
You are on interim bail.
yes, my lord.
Then let it be called. Let it be called.
My lord,
We will
Lord.
pass.
Oblige.
Cancel.
For motion, item number 1,
Made Lord, this 42 teacher Lord, filed for quashing of this charge sheet Lord. On the last occasion,
Yes,
on the last occasion, the scan copy of the
scan
Charge
copy
sheet was-
has,
not received.
but notices are not yet issued.
not it.
Let us issue notice.
Yes, the notice may be issued and matter may come up for admission. Along with
Heard Mr. R. Goswami, learned counsel for the petitioner. On perusal of the office note dated 7/11/2023, it appears that the scanned copy of the case record of PR case number 601/2022, which was called for in connection with this case, has not yet been received. Issue reminder for the scan copy, of the case. In the meanwhile, also issue notice to the respondents. As learned additional public prosecutor receives notice on behalf of respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from today, returnable after 3 weeks. Let this matter be listed after. You want a date? After 3 weeks. 30 November.
Oblige.
item number 2,
Yes, please, lordship, kindly pass over the time.
For the
item number 3,
I-
POXO matter.
POXO matter, my lord, POXO is added. However, I am for quashment of charge sheet, my lord. My lord, may I read, my lord, page 16 is the FIR.
notice may be issued.
My lord,
We are issuing notice.
my lord, in this case, my lord, but the Supriya Sultana Chaudhary, the case was registered against my father. Thereafter, my lord, at the time of investigation, police nothing recovered from me, not from my father, my lord. They filed a complaint before the magistrate. Magistrate pressurized the police. Police
Who
there,
pressurized?
magistrate might issued order to the police to complete the investigation. Accordingly, my lord, the police filed the report. As per report, my lord, police found that some IP address from the Facebook. And that address, my lord, which is connected to the target mobile number, which is connected to the Facebook account, my lord. And that mobile number not belongs to me, my lord. And that mobile number is not also recorded in my name, my lord. And only allegation, my lord, the police finding is that that mobile number is saved in my father's name as in Sukia Self-Bari. This is the only offense on that basis, my lord, I have been arrested. Whether it is an offense or not. Nothing recovered from me. The mobile number is not belong to me. The Facebook account
No,
also.
but there is evidence. Now you say that that evidence is not credible,
Not credible, and that evidence
that whether that can be decided now.
that cannot be decided, my lord. At least, my lord, I am the 19 years old, now 20 years, my lord, 20 years old girl, mother of a child, my lord. Due to this case, my lord, suddenly arrest of this case, my
No,
lord.
arrest, you have other relief for, if you are arrested.
Now my conjugal life is in distress, my lord. So husband saying that we cannot take your daughter, my lord.
Okay,
So now under such position, my lord, at least my lord, further action may be stopped, my lord, so that my conjugal life may be proceeded.
no, not without examining the
Yes,
record. We are issuing notice.
Yes,
As regards your other difficulties, you have
Yeah.
relief available.
yes.
We are issuing notice.
My lord, this is your lordship may write my maybe you should notice, my lord. Kindly take a note whether I have committed any offense or not.
That we
That-
will have to examine. That we can examine only after going through the charge sheet has been laid.
Charge sheet laid, my lord. So that I have challenged, my lord. That charge sheet I have challenged. That can be, my lord, further action may be stopped by the that at least for the sake of my conjugal life. Nothing recovered from me, my lord. Nothing recovered from me, my lord. The Facebook and also not belongs to me. This is another account, my lord. I don't know what is the name of this account. I never handled any Facebook account. I'm the only 18 years old girl, my lord. Later, subsequently, a number which is supposed
You are, what is your age?
now 20 years, man.
Well, let them file
You,
it.
once you said 18 years.
Yes, sir.
On my query, you said 20.
No, man, earlier, at the time of occurrence, I was 18.
And you have mentioned in your petition 21 years.
It's 21 years now, my lord. At the time of occurrence, 2 years back, my lord, the occurrence was happened. Now I'm a married girl, my lord, mother of a child, my lord. This marriage certificate I have annexed, my lord.
Who is Minal Ahmed Chaudhary?
Minal Ahmed, who is the respondent number 2, he is the informant, my lord. All allegation, my lord, everything, there is a land dispute, everything in the FIR, my lord. Originally, the father of mine and the Minal Ahmed Chaudhary had the land dispute, my lord. This is recorded in the my lord, FIR also. And that Minal Ahmed Chaudhary is being an advocate, filing cases after case against my father, my lord. For that, my lord, one complaint has been filed before the Bar Council by my father, my lord.
Okay, we'll consider your interim prayer after service of notice not responding.
Yes.
Mr.
H.R. Chaudhary.
H.R. Chaudhary. Also heard Mr. P. Borthakur. This application under section 482 of the Code of Criminal Procedure, 95 has been prepared by Rukia Sultana Chaudhary. Praying for washing of what is your prayer?
Watching of my lord, charge sheet. Prayer, my lord, page 10.
Washing of charge sheet filed in GR case number 1274 2022 arising out of current bench case number 412/2022. Issue notice to the respondent and call for the scanned copy of the case record of special POCSO case number 151/23 along with the case diary of case diary of Karimganj, scanned copy of the case diary of Karimganj PS case number 412/2022. As learned additional public prosecutor has appeared on behalf of respondent number one, no formal notice need to be. As regards respondent number two, learned the, as regards respondent number two, comma, the petitioner shall take step for issuance of notice by registered post with AD within 3 days from its date, returnable on given date of on 1st of December 2000. The prayer for interim relief shall be considered only after service of notice on respondent number two and on receipt of the scanned copy of the. Let this matter be considered again first of.
Item 3,
May it please use the lordship. My lord, it's a 438 application, my lord. The lordship will find the FIR at page 10, my lord. Well, I am not named in the FIR.
Yes.
My lord, may I read out, my lord? With due humble submission is that as per GD entry number so and so of Nelly outpost information received from a secret source that a group of 3 persons involved in ATM fraud and cheating were coming from Nagaon side to Guwahati side in a blue color Swift car bearing registration number so and so. Regarding this GD entry has been done by Nelly OP GD number so and informed to the OC Jagirod and superior officer. During Naka checking at about
This is,
7.
ATM scam.
Yes, my lord. What
The-
point?
The person who were apprehended were found to be involved in ATM.
Exactly.
Yes.
Then why are you
My lord, the car, my lord, the vehicle, my lord,
belongs to you?
it belongs to me. And the accused in that case is my brother. My lord. So I approached this court for Jimma of my vehicle, my lord. That order has been passed at page 22, my lord.
The vehicle is yours
The vehicle is mine.
and it was used after your consent. You knew that it will be used for.
Because my lord, it's a family car, my lord. The car is registered in my name, my lord. So the car was used, my lord. So when after obtaining this Jimma order, my lord, at page 22, my lord, when I approached the concerned police station, my lord, they are asked, they are asking, they are, my lord, going to arrest me, my lord. So therefore, I have approached this court. No allegation is there in the FIR.
Well, although his name is not there in the FIR, that vehicle granting Zimma is a, my lord, there is a different case in view of Sundar Bhai Ambala Desai. In view of that, my lord, this honorable court has earlier granted Zimma. But regarding his involvement, whether this vehicle was used by the other accused person with his knowledge.
No, main allegation is not of the use of the vehicle.
Yes,
It's
but
of ATMs.
yes, my lord, 37 numbers of ATM recovered from the accused who were apprehended at that point on time. Probably, my lord, case diary will reveal whether he is actually involved in the case along with other accused, my lord. And my lord, as per my information, my lord, today, your lordship has earlier rejected bail application of one Diwan Samsuddin, my lord, one of the accused. And CD probably, if your lordship can fix it very shortly, I will get case diary, my lord, within a very short period, my lord. Any date, my
Case
lord?
there is available today, my lord. Item number 15, my lord.
Not
Available.
available, my lord. As per my instruction, my lord, that my lord, IO has telephonically informed our office that CD he will deliver the case diary, my lord, within a short period. If you,
My lord, there is a problem.
Let
There-
when
any date, my lord, on 10th, my lord, Friday also I can
Day
produce the
after
case.
tomorrow. Yes,
My lord, my submission is that, my lord. Well, in the original case, my lord, today is 91 days. So the charge sheet is not played within the stipulated period of 90 days.
no,
So for other accused are concerned, my lord, they will get bail, my lord, by default today, my lord.
so charge, Yeah.
So but the IO
case
may,
will go back.
yeah, the IO may file the charge sheet, my lord, tomorrow or day after tomorrow. In that case, my lord, it is a charge sheet, then it will be a charge sheet. So therefore, I am praying for
But
it.
it will not make any change to your, suppose you are, without arresting you, I would make what you are apprehending.
As because, my lord, Jimma of the car has been given to me.
No, for that you can wait for 2 days. They
Yes,
will
but
produce
that's day after tomorrow.
day after.
Yes.
Oh, my lord, sorry, my lord. Tomorrow is the only working day. Monday.
Let it be on Tuesday.
Tuesday, yes.
Wait for it.
Fine.
Heard Mr. N.K. Dutta, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. Considering these submissions made by learned counsel for both sides, perusal of the case diary is felt necessary. Learned additional public prosecutor submits that he will be in a position to produce the case diary within a very short period. Hence, let this case be fixed on 14th of November. for
Right.
case.
Yes.
I'm obliged, my lord. Deeply obliged.
Item 52 of supplementary list.
Case diary was called for your worship.
Yes, my lord, in this case, my lord, case diary is today available, but regarding one another matter today listed before court number 9. So CD is in court number 9. So your lordship may kindly take it up at
I have to leave for, not for before right now, your worship.
to
My submission will be recorded, your worship. They will reply.
Okay, we will hear the petitioner.
Yeah.
You will be able to produce the case diary today.
yes, because regarding one another matter, my lord, case diary is in court number 9, my bail hearing matter. My. So thereafter, my lord, after finishing that matter, my lord, I can produce the case diary before your lordship, my lord.
But if it is a fixed matter before court number 9,
9 yes.
when we will be able to produce the case diary.
Item number 46 probably in court number 9 today.
I think very less time, your worship. Similar kind of matter was, being appreciated. Okay. By this honorable court. your worship. Document kindly come to page 27. The extension was allowed, prior extension was allowed. Because the UP Act is here.
Yes, Mr. Thakur.
Uh,
We may go ahead with hearing. Later on, you may produce the case diary.
yes.
That
Yes.
portion will remain after perusal of the case diary will pass order.
Yes, my- yes.
Yes,
Document kindly come to page 27. The prayer of extension was allowed. The mandatory provision is that
27.
page 27. now. From 90 days to 180 days.
No, 27 is a,
It's an order passed by the special judge, your worship,
no,
by which extension was allowed and also our bail
no,
application.
in the, here, the page 27 is something else. Page 27,
Yes, yes, worship. Yes, yes. Your worship.
you are citing wrong page. 27 is the reported Supreme Court case.
Yes, your worship.
In my file, my lord, that
What
was annexure.
Annexure 3, what is
Yes.
the,
Yes, and it's a which state?
না আমার এটা বলতে আছে
which annexure?
annexure 3 মানে
It is at page,
Annexure 3.
it is at page 25,
তুমি
Order dated 22/07/20.
22/8,
Yes, that is the order.
yes, it is at page 25.
By which the extension prayer was allowed and our bail application was rejected. The mandatory provision is that accused must be present when the prayer of hearing of the prayer of the IO for extension. That is missing in this impugned order. And the second thing is that the IO has to assign some ground by which the prayer of extension will be allowed. And also learned PP will give an individual view upon the ground which has been assigned to the honorable court. That is also missing. And we have argued another matter.
One is accused is not present.
Accused is not present because
Second
I
one-
was present, I
second-
was arguing the
second-
matter.
Second ground,
Second ground is that the grounds application,
I
I
has
think-
not mentioned the ground. No ground.
no ground. application. And also there is no individual remark by the learned CP. Individual ground has to be there because he may not forward or may not he may disagree the grounds assigned by the IO. And we are relying on one judgment which has been annexed in this along with our application, that is Hitendra Vishnu Thakur versus State of Maharashtra. Para 23 of that application, it specifically disclose that if the provisions have to be followed.
Para,
In our application, it has been,
no,
will find
which
it-
para of the cited judgment?
yes, para number 23. Lordship will find at para number 8, page 9, at from middle portion of it. Para number 23. From the middle portion.
Yes. You may.
The para
please-
number
please-
23.
Please read.
Please, I'm from middle portion, I'm reading the relevant portion of it. Para number 23 of the state judgment runs thereunder wherein it has been held that a public prosecutor is an important officer of the state government and is appointed by the state under the Code of Criminal Procedure 1973. He is not a part of the investigating agency. He is an independent statutory authority. The public prosecutor is expected to individually apply his mind to the request of the investigating agency before submitting a report to the court for extension of time with a view to enable the investigating agency to complete the investigation. He is not merely a post office or a forwarding agency. A public prosecutor may or may not agree with the reasons given by the investigating officer for seeking extension of time and may find that the investigation had not proceeded in proper manner or that there has been unnecessarily deliberate and avoidable delay in completing the investigation. In that event, he may not submit any report to the court to seek extension of time. Thus, for seeking extension of time, the public prosecutor, after independent application of mind to request the investigating agency, is to require to make and report to the designated court indicating there in the process of investigation and disclosing justification for keeping the accused in further custody to enable the investigating agency to complete the investigation. The impugn order that will reflect the appearance of the accused is necessary. He may not know the ground of his action, but he must be present. The accused must be present before the court. The court will not disclose on what ground the extension will be given. But they must be present. They were not present because on that they were also arguing the matter before the Senate Court of Appeal there. The accused was not present. At that time, I was also not present. And also, appeal prayer was there.
Okay.
And also, PP never made any submission. In a similar matter, this honorable court has quashed the order passed by the learned Court of Appeal Judge on that saying that the bail hearing was fake. But before 4 days, one application was made. On 18th,
Now, whether in this case, any application was, we have to go through the application.
and can you,
Whether that application made by IO is in record,
yes,
it is there.
that question was also being queried. Against the petitions also in the another case. In that, something was clear that no such steps were taken. Lost, but then it took me a second.
It took a certain.
Different thing. In the case cited in which the bail application was rejected on 22nd day, but the period of extension was allowed 4 days before. But in this present case, the extension was allowed in the same date and also bail application was subsequently rejected. And we have just relied on the very judgment, which has been also in the part of this application. There number 8, is number 9.
Yes, Mr.
My lord, here I would like to point out page 27, that is paste here in your lordship, my lord, record page 25, impugn order. First, my lord, in that earlier petition, the argument of the petitioner that, my lord, the petitioners, Mr. Hazal learned has got
The impugn order, you're referring
Yes,
to.
yes, impugn order, hard learned counsel for the petitioners and learned. So, my lord, it is not a case that, my lord, no notice was issued to the, my lord, accused person on his behalf, my lord. Counsels on behalf of the accused persons appeared, so notice was issued. And thereafter, my lord, in his petition, my lord, page 7, my lord, page 7 of the petition, my lord. My lord, paragraph 7, page 7 and paragraph 7, your lordship.
Yes.
Paragraph 7, my lord, 1, 2, 3, 8th line, my lord. The IO of the case through the learned PP file one petition by praying for extension of
Now,
details.
where will we find this petition? That
Yes, from the case diary, my
in
lord.
the case diary?
Case diary, my lord. So, my lord, now from the case diary, I will have to say whether that my lord petition was filed. And my lord, here in his petition itself, he has stated that that petition was endorsed by the learned PP. And my lord, here. As my learned friend has annexed one judgment of the, my lord. So, my lord, I will point out all these, my lord, expect what he has raised from the case diary, my lord.
When will you make your term?
That too, my lord.
There is a likelihood that we have a VC.
Yes. Yes, sir. On then, my lord,
No problem. It is submit.
on 16, my lord, 16, if possible, my lord,
Our
16 or 7.
Mr. R.P. Hazarika, the counsel for the petition. His part of the hearing is complete. However, Mr. P. Bhattakur, learned additional public prosecutor submits that the case diary, though it is available in this court, though it is available, is present, the case diary is presently available before
Yes.
some other court, and prays for some more time for producing the case diary and making his submissions.
17, 11,
Prayer is allowed.
17, 11.
Let this case
No.
be fixed on 17,
17, 11.
17/11, on which date an additional public prosecutor may make further submission.
Yes.
Let this case be listed again on 17/11 as part heard.
Deeply apply, sir. I will present now. Deeply apply.
For bail hearing, item 53 supplementary list.
Some direction was there to open the instruction from the IO.
Yes, my lord.
Yeah.
Yes, my lord. Your lordship may kindly, after some time, my learned friend has probably got the instruction from the.
Okay, we'll take it up after some time.
after some. আপুনি ছোৱালীজনীক মাতি এই যে নন্দিতা দাস অকমান বাহিৰত আছে নেকি মাতিব নন্দিতা দাস
We'll take it up as next item.
yes
Next
yes,
item.
after some.
All this item as next item.
Item 54.
না নন্দিতা করছেন নন্দিতা সাইড থেকে 54. Well, this matter may also kindly taken up along with 54, right? On counsel for the petitioner is also my lord. Understand.
9 and 10 bail hearing, BA.
Dada.
May please your lordship. Your lordship, LCR will call for in this matter, your lordship. This is a case of 2015, your lordship. Yeah, in item number 9, your lordship, the petitioner was arrested, your lordship. Subsequently, he was released on bail in 2015. Now it has been alleged that he had jumped the conditions of bail and he has not been appearing. So, your lordship, he has again been arrested on 3/8/2023 this year, and since last 98 days, he is behind the bar, your lordship. Your lordship, my humble submission is that he has never received any notice, your lordship, and neither any
No, you jump bill. The question of receiving notice does not correct.
No, your lordship, it is actually, your lordship, I have not appeared before the court. That is the allegations, your lordship.
No, you submitted that you were on bail.
Yes, your lordship. Your lordship, I were in bail, I were in regular bail, your lordship, in 2015, your lordship. Thereafter, your
During
lordship,
investigation period.
yes, your lordship. Yes, your lordship. In the investigation period, your lordship.
Okay.
In the year 2015, your lordship. Thereafter, your lordship, I was being a layman, I was doing my I was going with my normal life, your lordship. Thereafter, your lordship, COVIDs and all came, your lordship. And your lordship, I have not received any summons thereafter, your lordship. Suddenly on 3/8/2020, I was always available in my permanent address, your lordship. And I am ready to cooperate with the trial, your lordship.
Number 9. 9. 10 to
What is your name?
Your lordship, this is item number 9, Asikul Islam, your lordship. And your lordship, I was not even an FIR name accused, your lordship. I was not even an FIR name accused, your lordship.
No, those questions are not relevant.
Yes, your lordship.
After submission of charge sheet, the question is
Yes.
whether you are cooperating in trial or not,
Yes, your lordship.
or whether you are willfully evading the process of.
Lordship. Lordship, my humble submission is, your lordship, I am ready to, your lordship, cooperate with the trial, your lordship. Stringent, your lordship, condition may be, your lordship, impose upon me. I'll abide by it, your lordship.
No, while London trial court did not grant you bail.
Lordship,
Where is the rejection?
yes, your lordship. Your lordship will find, your lordship, your lordship, the latest order is on page 30, 2/9/2023. And page number 29 is the previous order, your lordship. Order dated 18/8, your lordship. I was arrested on the strength of warrant of arrest. And your lordship,
Why warrant of arrest was issued?
your lordship, because I was not appearing. I was not appearing before the court.
After after receiving the summons?
No, your lordship. I've never received any summons. Neither police visited my house, your lordship. In the meantime, your lordship. And I have raised this contention before the SDGM, your lordship. That order is on page 27/28. Order dated 16/8, your lordship.
When were you granted bail earlier?
Your lordship, in the year 2015.
Where is the,
Your lordship, that is not here, but it is there in the order, your lordship, in the
Where?
16, page number 27, your lordship.
where?
Your lordship. Your lordship, page 25, your lordship, I'm sorry, your lordship, page 25. From last para, your lordship, gone through the case record, page 25, last para. It transpires that while the accused Salahuddin was shown as an ex-convict in the charges, the accused Asikul Islam, though on court bail, jumped the bail even after receiving the summons, your lordship. But
So
the,
you are saying that you did not receive some.
no, your lordship, I was
But
not aware
the
of any.
observation of court is that you jumped the bail after receiving some.
Your lordship, the thing is that, your lordship, earlier in the year 2015, your lordship, I was cooperating with all the investigation. But in the meantime, when your lordship, this COVID and everything came, your lordship, everything got stuck, your lordship. I lost all communication even with my counsel, your lordship. Hereafter, your lordship.
No, you are unable to tell your story properly. I have to understand. During investigation, I have not gone through the record.
Lordship,
So you have to make submissions properly so that I understand.
lordship,
During investigation, you were granted bail.
lordship,
Then charge sheet was laid.
lordship,
Then summons were issued to you.
lordship.
You received summons.
Your
Your
lordship-
submission is that you
Your
have
lordship,
not.
as per my instruction, your lordship, they were not aware of anything. Either maybe they are ignorant, your lordship. But they have said me, your lordship, we have not received any summons, your lordship. And we are present in our present address. Even if NBW was issued, your lordship, that ought to have been sent to us. Or even before issuing NBW, bail-level warrant ought to have been issued, your lordship. That has not also been received by us, your lordship. Even if I would have received a copy of the order wherein your lordship warrant of arrest has been issued, your lordship, I would have appeared before the court, your lordship, that something has been going on, and your lordship, and I could have paid for bail here after, your lordship. But after I got arrested, I knew that
Yes, Mr. Das. Have you gone through the scan copy?
My lord, yes, I have also flagged my lord, regarding materials against this petitioner. So for petition number, item number 9 is concerned, my lord. Now, he is the person who, my lord, called my lord deceased on the pretext that his vehicle will be hired on rent for carrying some, my lord, vegetables from Dima field. And thereafter, my lord, the driver disappeared. Now, my lord, in this case, your lordship will kindly note, my lord, charge sheet was submitted on 31/3/2017, about 6 years back. And my lord, due to this conduct of the my lord, petitioners, my lord, even charges could not be framed till date. Charge sheet is dated, my lord, 31/3/2017. With all respect, I submit, let the charge be framed at least, and thereafter, my lord, the learned trial court will consider his prayer for gain. Because conduct of the petitioners are not, my lord, conducive, my lord.
You were arrested when the case was pending at committal, before committal court.
Yes, he was arrested. He was interrogated, but his
before the
statements under section 161 are recorded.
Okay, you received the summons. And you engaged a lawyer.
your lordship, it was perhaps back in 2000.
No, why perhaps? This is your case. You
Your
must know the fact.
Your lordship,
The record shows that on 37/2018, you engaged a counsel.
yes, your lordship.
to
That I
file a
submitted, your lordship, before COVID period, your lordship, I was there, your lordship, but during the COVID stage, your lordship, I have lost every contact with my counsel. The counsel has also not informed me, your lordship, that the court proceeding is going on and I need to appear before the court. Being a layman, uneducated person, your lordship, I was unaware of this proceeding, your lordship. And if bailable warrant was issued thereafter, your lordship, I ought to have been informed, your lordship. That has also not been done. Thereafter, NBW was issued, your lordship. That also I was not aware, your lordship.
There is one more accused person.
Yes, your lordship. There are two, actually. One died, your lordship, in the meantime.
What is his name?
Your lordship, item number 10 is the living accused, your lordship. And
No,
the
no.
other,
The-
Hussein died.
Mohammed Hussein, I think.
Mohammed Hussein died.
Who is Salu?
Salu is the
Salu is-
addition of item number 10, your lordship. Actually,
Full name is Salamuddin.
his name is Salahuddin, your lordship.
And the present petitioner's name is Ashikul.
Asikul, your
Asikul.
lordship. He is the youngest, your lordship. Now he's 28 years old. Back in 2015, he will be around 20 years
No, no, I don't want to hear these
old.
things.
Lordship,
I just want to comprehend the facts.
lordship.
Heard, Mr. What is that?
Your lordship.
Heard, Mr. I say that the counsel for the petition. Also heard Mr. E. Das that the petitioner for prosecution. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Ashikul Islam, who has been detained behind the bar since 2/8/2023, within bracket, since last 98 days, in connection with Sessions case number 203/2023, pending before the Court of Learned Sessions Judge Sonit, corresponding to the Haridwar PS case number 168/2015 under section 406/34/302/201/392 of the Indian Penal. Learned counsel for the petitioner have submitted that earlier the petitioner that during the investigation period of this case, the petitioner was on bail.
Yes, your lordship.
This is not correct, sir,
Your lordship,
because the order shows that you were shown as an absconder in the charge. If
lordship, that's a
Item
different.
number 10.
This is the item number 10, your lordship.
Salu Ahmed.
Asikul was,
Ashikul
Asikul
was,
was
Okay.
arrested, he was
and it is also
Okay.
classified by the order.
and he was sent up for trial, and this Asikul, and he is soon as conduct.
he was on bail during investigation period. And when the charge sheet was filed, after filing of the charge sheet, summons were issued to him. And he engaged a counsel to represent him before the Learned Committal Court. However, he defaulted in appearing before Learned Committal Court due to COVID, which was prevalent at that point of time. It is further submitted by Learned Counsel for the petitioner that due to default of the present petitioner to appear before the committal court, Learned Committed Court issued non-bailable warrant of arrest against him without first taking recourse to issuing bailable warrant of arrest. And thereafter, he was arrested
On 3/8,
on
3/8/20.
3/8/2023, and since then he is languished behind the bar. Learned counsel for the petitioner has submitted that the petitioner is willing to cooperate with in the trial under any condition which may be imposed by this court. On the other hand, learned additional public prosecutor submits that the conduct of the petitioner is not cooperative. Conduct of the petitioner shows that he is not cooperative, as he defaulted after receipt of summons and even after appearing before the committal court by engaging a counsel. So, you're opposing the bill. Learned additional public prosecutor has opposed the grant of bail. I have considered the submissions made by learned counsel for both sides and have gone through the case, scanned copy of the case record of this, scanned copy of the case record of case number 203/23, as well as GR case number 3203/2015. It appears from record that the petitioner had engaged a counsel to represent him before learned trial court, learned committal court, and he had filed a petition before learned committal court on 30/7/2018, which was allowed. However, thereafter he defaulted. It also appears that on the next date, that is on 24/1/2019, learned committal court issued non-bailable warrant of arrest against the present petitioner without taking course issuing bailable warrant against him. At what stage it is pending?
Lordship, it has been committed to the session court, your lordship. Now, your lordship,
Pending for coming of charge.
coming up.
Charge is yet to be framed.
It also appears from record that the trial is pending at the stage of framing of charges, and since last four dates on which the case was fixed for framing of charges, the case has not progressed. So, considering the fact that the petitioner has been detained behind the bar for last 98 days, and also considering the reasons shown by learned counsel for the petitioner for the default of the petitioner to appearing before the court. And also considering the fact that the petitioner is ready to cooperate in this trial, this court is of considered opinion that his further custodial detention may not be necessary if he cooperates in his trial. Stop. In view of above, the petitioner Ashikul Islam is allowed to go on bail of rupees 30,000 with one surety of like amount subject to satisfaction of Learned Sessions Judge Sonitpur, who may impose any additional condition of bail if he deems fit to do so before accepting the bail bond. With above observation, this bail application is hereby dispersed. And this is
Item number 10. Your
same
case, your lordship. Here, what happened, your lordship, I have been thrown as an responder. Now, the thing is that, your lordship, the case has been filed against one Salu. I am Salamuddin, your lordship. Your lordship, FIR will transfer, your lordship, even my father's name is not known and my actual name is not known, your lordship. Thereafter, in the charge sheet to your lordship, my name is shown as Salu and my father's name is unknown. So, your lordship, never I was inquired upon, your lordship, not a single summon was even sent by the police authorities, your lordship, to my house. I was even unaware until 3/8/2023 that a case has been pending against one Salu, and police and the authorities believe that Salamuddin is Salu, your lordship. The FIR and search sheet, it clearly shows that they don't even know my address, your lordship. So the question of issuing summons, even under section 41A also doesn't arise, your lordship. And earlier it was not a case of 302, your lordship. So, your lordship, police never charged for me. They have never issued any summon. They have never conducted any inquiry. The case was going on, and on 3/8/2023, your lordship, I was they held that Salu is Salamuddin, and I was arrested from my address, your lordship, my residential address. I was always present here, your lordship.
When warrant were issued?
Your lordship, should be the LCA, your lordship.
Mr. I Hussain, I'm counsel for the petitioner. Author Mr. T. Das, petitioner. This application under section 439 of the Code of Criminal Procedure, 1973, has been tried by the accused, by the petitioner Muhammad Salamuddin alias Salu, who has been detained behind the bar since 3/8/2023, within since last 98 days. Learned counsel for the petitioner submits that the petitioner has never received any summons from the trial court, and he was directly arrested on 3rd of August 2023, whereas he was all along available in his residence. It is submitted by learned counsel for petitioner that the name of the present petitioner is shown as Salu in the charge sheet, and his father's name is also wrongly shown in the charge sheet,
His father name is shown as unknown.
shown as unknown. And therefore, he never received any summons from the learned trial, from the learned trial. Stop. I have learned, learned additional public prosecutor submits that the, as regards Salu, what is your submission?
Well, he is an absconder, he has been shown
That
absconder.
that the present petitioner was shown as an absconder in the charge sheet, and due to non-cooperation
He
by
did not
the-
cooperate with the investigation.
by the present petitioner, this case which was instituted in the year 2015 is pending for so long. And accordingly has opposed the grant of bail. I have considered the submissions made by learned counsel for both the sides and have perused the case. Perused the scan copy of the case record of GR case number 303203/15, as well as case diary, scan copy of the case diary of Charidwar PS case number 168/2015. On perusal of the case record, it appears that the present petitioner was shown as an absconder in the charge sheet, and initially summons were issued by the learned committal court to the petitioner. However, it transpires from the transpires from the record that on 11/8/2022, non-bailable warrant of arrest was issued against the present petitioner without receiving any service report as regards the summons issued to the present petitioner, which shows that the petitioner did not receive any summons from the issued by the learned committed court. Stop. Considering this fact, as well as considering the fact that the present petitioner has been detained behind the bar since last 98 days and is ready to face trial and cooperate with trial, his further custodial detention does not appear to be necessary for fair completion of the trial of the case. Hence, the petitioner Salamuddin alias Sal is hereby allowed to go on bail of 30,000 with one surety of like amount to the satisfaction of learned sessions judge Chronic Court, who may impose any additional condition of bail at the time before accepting the bail bond in the case. With above observation, this later.
Good luck.
Item 11.
Well, 449 application, both the accused are in jail. The price paid 15 my lord.
This
Allegation
is
is
a charge sheeted case.
considered charge has been framed, evidence has been started. They are in jail more than 100 days. Sir.
Since when are you in jail?
Pardon?
When were you detained?
For more than 100 days. 2nd of August.
Since 2nd of August.
2nd of August, my lord, behind the bar, along with a different dumb file, my lord, 6 years of bail.
What is the allegation?
Allegation is, my lord, 306. Abatement. Well, it is pure suspension. FIR was filed after 1.5 months. Whatever maybe, my lord, the investigations have been completed. Charge sheet filed. Charge has been framed, my lord.
Why the trial court is rejecting your bail?
Rejecting, my lord, kindly page 20, my lord. Page 21. the accused persons at this stage may hamper the prosecution. My lord, that was the death bail petition was filed after coming of charge man.
Your husband and wife,
No, no, no. My lord, the wife and the brother of the wife. Rajan Sarkar is the brother of the wife who resides in more than 30 kilometers away from the place of occurrence.
and who died?
My lord, the mother-in-law of the accused number one man. Complainant mother, my lord, in mother-in-law of the accused number one man, Bonalata Sarkar.
The trial is at evidence stage.
Evidence stage, my lord.
How many witnesses are? Caught?
No, my lord, no examination.
Since
was.
when it is pending?
My lord, last evidence was fixed on 13/10/2023. That was not the examination of witness. And tomorrow is the date fixed for cross examination of the my lord.
How many witnesses are recorded?
Oh, my lord, total 5. I have 500 the statement of all the witnesses, my lord, in additional affidavit. And the
Why-
last of it,
Why have you filed it? To show what?
Pardon?
To show what?
no, my lord, it was direction of the my lord, this court, my lord. In earlier, it was asked to file the my lord, the evidence. Before, in that time, my lord, the LCR was not received, my lord.
Yes.
Well,
Well, the prosecution story is.
How many witnesses were listed witnesses were there in the chat?
5.
Out of 5.
No examination, my lord. No any witness was examined.
My query is how many witnesses were listed in the chat?
Five.
Out of 5, how many are examined already examined?
No, my lord.
No witness is yet.
I examined. First one examination date was on 13/10, and tomorrow is the second date, man. 13 it was not exam.
Where is the additional affidavit? Additional. Yep. There is no additional affidavit.
It was filed on 16th of October, man.
शामिल होने की रिपोर्ट ये है तो कॉपी
You have submitted 161 state.
161 state.
that is there in the report. I have flagged marked.
Now what is your submit?
My lord,
They will be facing trial.
Yes.
So why to detain them?
that but proceeding
Unless there is an allegation that they are threatening the witness or some other allegation. There is no such allegation. Why the trial court rejected your bail? Where is the rejection order?
Page 20.
This rejection order is of which date?
For the 21st/9/2022. Page 20, Annexure 3.
No, it is observed that you may hamper the bail.
Yes.
Hamper the witnesses on what basis?
Yes, Maharaj. That has been, that is it.
There is no basis. Mr. D.K. Das, counsel for the petitioner. Also heard Mr. D. Das, additional public prosecutor. this this application under section 439 of the Code of Criminal Procedure Human 1973 has been filed by the petitioners, namely Srimati Banulata Sarkar and Shri Rajen Sarkar, who are detained behind the bar since 2/8/2023 in connection with Sessions Case number 209/2023 corresponding to Tarabari PS case number 59/2023. Learned counsel for the petitioner. When were you arrested? During
Sir.
investigation.
Yes, ma'am.
Learned counsel for the petitioner has submitted that the petitioners are detained behind the bar since more than
100 days.
100 days. And they are facing trial in Sessions Case number 209/2023. It is all, where do you reside?
Tarabari, madam.
It is also submitted by learned counsel for the petitioner that both the petitioners are the permanent residents of village. Now, the petitioner number 1 is the permanent resident of village Badgaon under Tarabari police station, whereas petitioner number 2 is the resident of village Bamundi under Sotnebari police station in Barpeta district. And they are willing and ready to cooperate in the trial. It is also submitted by the counsel for the who is having deep and up there.
Madam, the child of the petitioner number 1, madam.
She
He is age of 6 years, madam.
with the mother
With the
inside
mother.
jail, inside the jail.
Inside the jail.
Learned counsel for the petitioner submits that the petitioner number 1 is also having a deep and dumb child of 6 years of age, who is also staying with the petitioner number 1 inside the jail. Stop. It is further submitted by learned counsel for the petitioner that the petitioner had referred a bail application before learned trial court, which was rejected on 21/9/2023 on the ground that bail to the accused persons at this stage may hamper the prosecution's case. However, no reasons has been cited in the said order as to why the said observation was made or what was the basis of making such an observation by rejecting their bail petition. So considering the above circumstances, as well as considering the fact that the petitioners are ready to cooperate in trial, their custodial detention does not appear to be justified, does not appear to be necessary for fair completion of the trial of Sessions Case number 209/2023 if they cooperate with the trial. Stop. In view of above, both the petitioners, namely Banulata Sarkar and Rajen Sarkar, are hereby allowed to go on bail of 30,000 each with a security of like amount subject to satisfaction of learned sessions judge report. who may impose any additional condition of bail at the, before accepting the bail bonds if he so deem it fits. With above, deem it fit. With above of the with better.
All right.
Item 12,
Lordship may kindly pass over the matter for the time being.
13,
May please, your lordship, the 439 application lordship, charge-sheeted case lordship. The petitioner was arrested 27/3/2023 lordship. Today is 136 day.
What is the
136.
stage of investigation?
The
State of. state of
appearance
trial.
lordship. Another accused is not appeared before the trial court.
What was the allegation?
Allegation is serious lordship.
Serious allegation.
Lordship.
Then you have to pay.
FIR case 10 lordship. Stepfather and mother are the accused. Lord.
The witness will be the daughter, will be the witness.
Yes.
Victim is the victim.
The stepdaughter petitioner.
Because if at this stage, if you are released on bail, there is every likelihood that you will influence.
No, no.
Yes, Mr.
Any condition less with the case the trial.
Records are, full records are not there, 164 statement is not complete.
What is there in 164?
Hmm.
Why the trial court rejected your bail?
The lordship, the
Where is
at
the
the case 24. lordship. At this is.
No, this is the case has been committed to session court or not?
Not. Judicial miss first class.
Appearance
now.
is yet to be completed, one accused is not appearing.
Next date 18/12 for SR service report. The length of detention of any condition.
Yes, Mr. Patel.
My lord.
What is your sub? Who is the accused?
Date of birth certificate is not there in the, lord. And according to the birth certificate, she was minor.
Mother's witness is not there. Mother's witness is the necessary. Lord.
2009, our date of birth.
Where is the FIR?
Is 10 lordship. Cancel it.
Particular is at page 14.
14 lordship. Victim is the informant.
The petitioner is Majbul Ali.
Muzbul Ali.
He is the only petitioner
Yes, Lord.
before in this bail application.
Yes. In the search center, he is the condol. He has no knowledge about the pending of the cases. 15 cases. Lord. He was arrested in the 2023. Lord.
Cash sheet is laid under what What provision? Under section,
Case lordship 16.
POXO is not there.
No lordship. 120B, 376F. POXO is not there. FIR lost the victim lordship. Is the measure.
No, at this stage, I am reluctant. Let the trial court decide.
Trial court lordship the
Because if you are released now, the victim is your own stepdaughter. Third,
any condition lordship to grant
heard
bail
Mr.
lordship.
Majbul Ali, learned counsel for the petitioner. Also heard Mr. T. Das, and additional public prosecutor. This application under section 439, the Code of Criminal Procedure 170, has been filed by the petitioner Majbul Ali, who has been detained behind the bar since 27/6/23. 27/6/23. It's last 136 days. Now, why it is so long pending for committal?
Lordship, he was arrested, lordship. 27/6 lordship.
Now, why the case has not been committed?
The another request is not required before the trial court. The next date is the
I'm
eighth-
not zoning it, huh?
Mother-
Mother
mother.
is, the application is there.
The
No,
mother-
order sheet is reflected.
The mother was not stay with the present petition. Till I have no knowledge why he was decided.
The accusation in this case is that on 9/1/2015, the victim of this victim/informant lodged a victim/informant, who is the stepdaughter of the present petitioner, lodged an FIR before the officer in charge of Hattigaon Police Station, Guwahati, inter alia alleging that she was subjected to repeated forcible sexual intercourse by the present petitioner. And present petition. Stop. After completion of the investigation, charge sheet was laid against the present petitioner
36.
and
2020.
one more co-accused under section 376 within bracket F/120B of the State Penal Code. The case is still pending before the committal court, as the attendance of other co-accused could not yet be procured. Learned counsel for the petitioner has submitted that the petitioner is ready to face trial and on any condition fixed by this court. On the other hand, learned additional public prosecutor has produced the scanned copy of the case record of PRC case number 15 03/2023 and has opposed the grant of, you are opposing, oppose the grant of bail to the present petitioner on the ground that the offense involved in this case is heinous in nature and the victim is the own daughter of the present petitioner, and there is every likelihood that the if that the petitioner may try to influence the victim who is his own stepdaughter. Therefore, learned additional public prosecutor prays that the examination of victim, that the prayer of bail of the present petitioner may be considered by the learned trial court only after examination of the victim. The submission of, I have considered the submissions made by learned counsel for both the sides and have gone through the scanned copy of the case record of PRC case number 1503/2023. Considering the nature of the offense involved in this case, and also considering the fact that the petitioner is the stepfather of the victim girl, I find the submissions made by learned additional public prosecutor fair and reasonable. Stop. This court therefore does not intend to give benefit of bail to the petitioner at this stage and leave it on the petitioners to move the learned trial court, making prayer for bail before learned trial court after examination of the victim girl. With this of the petition will happen.
Lordship, is the merit till now, Lordship, the victim, Lordship. He has no the earlier address, Lordship. Why
No,
he has to
no,
present before
not
the trial
victim
court?
What was the last? Not after. Cut that last bit after exam. You may make your prayer before
Trial court, Lordship. Consider the bail
at
petition.
appropriate.
Lordship, one says to consider the bail application as per.
No, that courts always consider. Direction from this court is not necessary.
Even if it is not safe.
If you file a petition, court will consider.
Item 14.
May I please, your lordship? My lord, this is a 439 bail application, my lord. My lord, petitioner was behind the bar since last 6/10, lordship. Today is 35 day behind the bar. Lordship, FIR is at page 9, lordship. Lordship, that FIR was lodged by the manager of the corporation bank, lordship, mainly against the manager of the bank, lordship. With an allegation that some amount was misappropriated, lordship, in collaboration with the present petitioner, lord.
Who is the present petitioner?
Present petitioner is the one of the beneficiary of the KCC loan, lordship. Only an amount of rupees 84,000, lordship, he had taken as a KCC loan, lord. Page 9 is the FIR, lordship. Page 10, lordship, my name is there, lordship. Asu Hussain Laskar. That allegation is an amount of rupees 84,000 I have taken, lord. As a KCC loan. So thereafter, lordship, petitioner, lordship, had no knowledge, lordship, about that FIR, lordship, actually.
Whether petitioner's statement has been recorded.
Yes, my lord, no, this is my lord, BA, my lord. Statement is
Who will be
available.
appealing?
BA, statement is available.
Statement
Is available. Otherwise, my lord, in this case, my lord, this FIR is lodged by the my lord, Deputy General Manager of the Corporation Bank, Silchar branch, my lord. He is one of the borrower of the my lord, loan. those in this, my lord, affair, along with the petitioner borrowers, some of the bank officials are also accused. Against the present accused person allegation that he took an amount of rupees 84,000 by submitting, my lord, false document. So he has also admitted that he received an amount of rupees 84,000 for which he bribed, my lord, bank officials, and they are on the basis of, my lord, false document. And till now, he has not repaid, and my lord, the case is of 2016, and on my lord, 6/10/23, he was arrested from airport.
Yes, sir.
Well, while probably he
Now his statement is recorded.
statement record.
His
He admitted, in fact.
detention is not necessary.
Yes, documentary. Otherwise, my lord, in his statement also, in his petition also, he assured to repay, but till now he has not
But
paid.
for repayment, you cannot detain.
Yes, exactly, my lord. But problem is that, my lord, he lives in foreign country for last, my lord, 4 years. My lord, now, only now, my lord, while he is about to, my lord, leave, then, my lord, police arrested him from the airport. My
No,
lord. That
lordship.
is the only difficulty.
Actually, lordship, that bank was closed, lordship. Petitioner is a semi-literate person, lordship. In the year 2021, lordship, when he received one
About
notice,
to leave where?
lordship, he residing in Dubai, lordship, for maintaining his livelihood, lord.
Okay, then if we allow you to go on bail, how your presence would be procured?
Lordship, because lordship, now my residence is at Silchar, lordship, in that area, lordship. I will be very much available, lordship, as per conditions. Lordship. Because lordship, for maintaining my livelihood, in the year 2021, lordship, I have received one notice from the BIO, lordship. Thereafter, I inquired, lordship, but that found, lordship, the corporation bank was amalgamated with the Union Bank, and that branch was not there. Even now, lordship, I am able to repay the amount.
No, repaying part is the allegation is of forgery and
Yes, lordship. Actually, lordship, that lordship, I approached the bank
no
officer.
what condition may be imposed?
Let him after, my lord, during continuation of this case, he may not leave, my lord. That may
You
be.
leave after completion of investigation.
Yes.
With permission of the lordship, IO, lord. If lordship is allowing me, lordship, then because lordship, my main livelihood is there, lordship, in Dubai.
No, you have two options, either to remain in jail or to go to Dubai.
Lordship, any condition, lordship. Yes.
Mr.
NH Borbia.
NH Borbia, Learned Counsel for the
Sorry, lordship.
Okay, heard Mr. Okay. Item number 14. Heard Mr. NH Borbia, Learned Counsel for the petitioner. Also heard Mr. P. Borthakur, Learned Additional Public Prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Jour Uddin Laskar.
No, lordship, Asu Hussain, lordship.
Oh, your father, Asu Hussain Laskar, who has been detained behind the bar on 6/10/2023 in connection with BI within bracket EO PS case number 2/2016 under section 120B/1420/409/468 of the Indian Penal Code. The gist of accusation in this case is that on 14/2/2016, the Deputy General Manager of which bank?
Corporation Bank.
Corporation Bank lodged an FIR before the Superintendent of Police, BIEO, Guwahati, inter alia alleging that the present petitioner, in connivance with whom, against whom the main allegation,
With the branch manager of the
with the
bank,
branch manager of which bank?
Corporation Bank.
Corporation Bank,
Silchar branch,
Kacha,
Silchar branch.
Silchar branch, misappropriated the money of bank to the tune of rupees 84,000 by obtaining loan by furnishing forged documents. Stop. Learned counsel for the petitioner submits that. What is your submission?
Lordship, after filing of that FIR, Lordship, because at that point of time, Lordship, I was unable to repay, Lordship, because I was unemployed, Lord. And thereafter, Lordship, I went to Dubai and for maintaining my livelihood and some good amount, Lordship, income, Lordship. Then I approached in the year 2021, Lordship, for repayment, Lordship. But during this time in the year 2020, already bank was amalgamated. So that branch was closed. So I could not able to repay, Lordship. Now I am ready to repay, Lordship.
Learned counsel for the petitioner submits that the allegations of forged document.
Lordship, that branch manager, Lordship, because I approached the branch manager, Lordship, and he issued me, Lordship, because he had taken also an amount of rupees 10,000, Lordship, out of that 84,000, Lordship. He prepared the entire records, Lordship, with his agent, Lordship. So I have not aware, Lordship, about, because
Learned counsel for the petitioner submits that he is not aware about the allegation made.
But those amount were received in his account. Thereafter, he knows.
Made in the FIR, and he also approached the bank to repay the loan of rupees 84,000 which he had obtained from the bank. However, in the meanwhile, the corporate bank had already amalgamated with
Union
Bank of India, and due to which he was unable to repay its said loan. On the other hand, learned additional public prosecutor has produced the case diary of BIEO PS case number 2/2016 and has submitted that there are incriminating materials against the present petitioner. However, he has also submitted that the investigation has fairly progressed and statement of the present petitioner has already been recorded by the investigating officer. Considering the submissions made by learned counsel for both sides, as well as considering the materials in the case, that further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of BIEO PS case number 2/2016 if the petitioner cooperates with the investigating officer in fair completion of the investigation. In view of above, the petitioner Asu Hussain Laskar is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of learned Chief Judicial Magistrate Kacha Silchar.
Kamrup.
Case is pending here.
Pending here.
Subject to
Kamrup Metro.
Chief Judicial Magistrate Kamrup Metro with following conditions. His further custodial detention, his further interrogation is necessary. Or
now already his statement recorded, consider there are sufficient materials no doubt in the case there, but Already he admitted he has committed the offense. So, my lord, only he shall not be allowed to leave India, my lord, till completion of the investigation without permission from the jurisdictional court.
Yeah, without permission of the jurisdiction.
The petitioner with following condition. Number one, the petitioner shall deposit his passport before the learned court of learned Chief Judicial Magistrate Kamru, and he shall not be allowed to leave the jurisdiction of the said court without prior leave of the said. You may leave after obtaining.
Yes, Lord, prior permission is required, but Lordship, that jurisdiction of the court, Lordship, because my residence is at Silchar. So.
Case is pending here, my lord.
Case is pending here.
Case is pending here, Lordship, but that jurisdiction of the court, Lordship.
No. No, what was the? Chief Judicial Magistrate. No, jurisdiction of, he shall not allowed to leave the state of Assam without prior leave of the learned Chief Judicial Magistrate Kamru, and he shall cooperate in the investigation with above of the. I'm taking 2 minutes.
For 39 application, Lordship, today is 92 days. Lordship.
Same Zagiud PS case number 238/23. This case, charge sheet not submitted. As per my instruction, my lord, charge sheet not yet submitted.
So already statutory period.
Period completed. Yeah.
92 days.
The third, Mr. N.J. Datta, uncounted for the petition. Also heard Mr. P. Borthakutan with additional prosecutor. This application under section 439 of the Code of Civil Procedure, 1973 has been filed by 3 numbers of petitioners, namely Dewan Samsuddin, number 2, Hanifur Rahman, number 3, Saidul Islam Ilyas Shahidul Islam, who are detained behind the bar since 9/8/2023 within brackets since last 92 days in connection with Jagirod PS case number 238/2022 under section 237/3/07/427/420/470/34 IPC. Stop. Learned counsel for the petitioner has submitted that the maximum period of detention for the offences alleged against the present petitioners in the instant case with 90 days under section 167 clause 2 of the CRPC, and therefore the petitioners are entitled to get statutory pay. Stop. Learned additional public prosecutor also submits that the statutory period of detention of 90 days in the instant case has already been over, and therefore does not oppose the grant of bail to the present petitioner. In view of the above named petitioners are hereby allowed to go on bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the
CGM Morikawa.
Chief Judicial Magistrate. As of observation, this bail application.
I'm obliged.
There was 16 case, they did not receive me.
well, time behind the bars is 34 days. Perhaps section 489C will come, and that section is available, 7 years in prison.
But for that, we have to go through case.
Yes. Kindly have a thought.
Heard Mr. J. Paramani. Learned counsel for the petitioner, also heard
Again,
Mr.
both case.
P. Berthakur, learned additional public prosecutor who praised for another date for producing the case that the prayer is allowed. Let this matter be listed on
22/11.
22.
Can it be possible on 14? Well,
14?
this is Boko Kampo.
No, for
Boko Kampo.
apart from 14, some other day,
17/11.
17.
I leave.
17?
At least, my lord. My lord, 439, my lord. You cannot behind the park for 3 days, my lord. My lord, registered under section 366.
When were you arrested?
My lord, as per my information,
39/23.
I was arrested on 28, forwarded on 30.
38.
39/23. 40 days.
Look, otherwise, the petitioner is the alleged victim of the law of attack. The alleged victim herself, my lord, he come to the petitioner. And finding that, brother of the victim girl, my lord.
Victim is a major girl.
My lord,
As per FIR, my lord, it was written as 17
birth
years.
certificate, as per birth certificate, her date of birth 17/9/2006. And she is missing since 26/9/23. About to, my lord, is 19.
But
Statement
Completed 18. Statement record. From her 164 statement, she has not implicated the present accused person.
Heard Mr.
yeah, Mahatan.
A.
Yeah, Mahatan.
A. M. Hassan. Learned counsel for the petitioner, also heard Mr. P. Berthakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Nurul Amin, alias Nurul Amin, who has been detained behind the bar since 28/9/2023 in connection with South Salmara Police Station, case number 287/23, under section 366 of the Indian Penal Code. The accusation against the present petitioner is that on 27/9/2023, one Kabir Hussain lodged an FIR before the officer in charge of South Salmara Police Station, inter alia, alleging that since 26/9/2023, his sister was untraceable, and later on, it came to the knowledge of the first informant that the present petitioner enticed his sister and took her away to some other place. Stop. Learned counsel for the petitioner has submitted that the petitioner was having a love affair with the victim girl, and the victim girl is a major, and she came along with the petitioner on her own. Stop. Learned additional public prosecutor has produced the case diary of South Salmara PS case number 287/2023. And the investigation has fairly progressed, and the statement of victim girl has been recorded under section 164 CRPC. And it is submitted by learned additional public prosecutor that victim girl has not implicated the present petitioner in this case. Stop. Considering the submissions made by learned counsel for the petition, learned counsel for the parties as well as considering the materials on record. This court is of considered opinion that further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of South Salmara PS case number 287/2023. View of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of liability, subject to the satisfaction of learned Chief Judicial Magistrate, South Salmara. Monka, comma, Monka. With above observation. Bail application. Stand back.
Well, I would like to point out one more, although in 164 statement, her age is mentioned as 17 years on 4th October 2023, but in the case diary, one birth certificate is also available. And as per that birth certificate, her date of birth is 17/9/2000.
Okay, I have not
Yes,
mentioned,
yes.
only I have recorded his state.
Yes, yes. Okay.
Finding item 12.
I think.
May it please your lordship. There's a 439 application, my lord, in a charge sheet case, my lord. My lord, it's a POCSO case, my lord. We have taken steps, my lord. The informant has also appeared today, my lord. My lord.
Yes.
Here, my lord, I am in detention for 245 days, my lord.
At what stage the trial is pending?
My lord, now, my lord, it is in the evidence stage, but no witnesses has turned up. 7-8 days has gone, my lord. No witnesses has turned up. Lordship, may kindly see page 34 onwards, my lord.
The scanned copy of the case record was
My
for,
lord.
it is there.
Page 35, my lord. Page 35 onwards, my lord. No PW is present, my lord. It goes on and on, my lord.
Since when the evidence started?
Well, evidence has not started, my lord. No.
When was the first?
Charges framed only, my lord.
When the charges were framed?
Charges were framed on, my lord.
30th of May.
30th of May.
Yes. 30th of May.
Considering the detention, my lord, and my lord, no witnesses has been examined till now, my lord.
Who is the victim?
A victim is a, my lord.
Victim is the night of the informant. One, he has come today and signed one affidavit.
What affidavit?
Well, regarding bail, well, he has no. That has signed, well, today he has appeared today.
The victim is the niece of.
Informant.
Yes.
One second, taking things.
Now, whether the victim has received the summons from trial court.
My lord,
From the trial court.
Yes.
Not from the.
my lord, informant.
No, my query is.
Trial court of a
Yes, from trial court, my lord. Yes, that's what has manifestation.
So why she is not appearing before trial court? Or is it evident? No, victim is present.
My lord, present, my lord, informant is present.
You consult.
Yes, ma'am.
You have instructions
Yes.
from informant and
She-
let this court know. Why the. What is your submission, Mr. Das?
My lord, as per her statements, she has implicated him, my lord, directly. With the help of her friends, my lord, she was taken to a place, my lord, alluring her on the plea of having a stroll
Then why she is not opposing the bail? On what ground she is? No, just I want to know.
Because she is also married wife. So.
As per my instruction, she has married, my lord, now, my lord.
Okay.
And now, my lord, she is living in a, my lord, different, and now she don't want to, my lord. Don't want to pursue further with her. She is married happily with her.
Okay. Heard Mr. S. M. Abdullah P. and counsel for the petition. Also heard. Which is item number?
12, my
lord. Also heard Mr. T. Das and additional public prosecutor as well as Mr. S. Sikdar, who is appearing for
SH, my lord.
S.H.
H.
S.H. Sikdar, who is appearing for the informant. Informant within bracket respondent number 2. So this application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Saib Ali, who has been detained behind the bar since last 10/3/2023 within bracket since last 245 days in connection with POCSO case number 67/23 under section 366/376/342 of the Indian Penal Code, read section 4 of the POCSO Act, 2012, which is pending before the Court of Learned Special Judge within bracket POCSO, Morigaon. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar since last 245 days. And though the charges were framed against the petitioner on 30/5/2023, however, till now, no witnesses has been examined in the said trial. Learned counsel for the petitioner has further submitted that the petitioner is ready to face trial and ready to cooperate in his trial. On the other hand, learned additional public prosecutor has produced the case diary of the Jagir Road PS case number 80/2023 and has submitted that there are implicating materials against the present petitioner in the case diary and has opposed the grant of bail to the present petitioner. So, on the other hand, Mr. S.H. Sikdar, who is appearing for the respondent number 2, has submitted that the has furnished an affidavit shown by the victim girl, wherein it is stated that the victim girl has no objection if the present petitioner is allowed to go on bail at this stage. Stop. Learned counsel for the informant has also submitted that the informant is the maternal uncle, who
Maternal auntie.
maternal aunt of the victim girl. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on the court. It appears that the present petitioner has undergone a long incarceration of 245 days. It also appears that though the charges were framed on 30/5/2023, however, thereafter several dates were fixed for recording evidence of prosecution side. However, till now, not even a single witness has been examined in the said case. So, considering the above fact, along with the fact that the victim has not opposed the grant of bail to the present petitioner, further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of this case. Hence, the petitioner Muhammad Saib Ali is hereby allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of learned special judge Poxo, Morigaon with following condition that he shall appear before the learned trial court as and when so required by the learned trial court and shall cooperate in the trial. Number 2, that he shall not directly or indirectly make any inducement, threat, or promise to the victim girl or to any person who may be acquainted with the facts of the case, so as to dissuade such person / victim to disclose such fact before the learned trial court during the trial. With above observation, this bail application thereby.
Please, Blank.
Standing item 53.
Well, as per my instruction, my lord, from the IO, the accused person appeared before the IO and his statement recorded. And regarding postmortem report is not conclusive. He received the postmortem report. Now, final, my lord, FSL report not yet received. My lord. That is the instruction from the IO. My lord. Otherwise, my lord, in the case diary, there are sufficient material against the accused person. My lord. And before this incident, also one another incident earlier happened. And for that, the victim was earlier also, my lord, admitted in Dibrugarh Medical College Hospital. And from that, my lord, during treatment, my lord, in spite of the consent of the my lord, doctors, my lord, he forcefully taken away the victim from the hospital. Regarding that, notice also available.
This is a 306 case.
Yes, yes. But there is no any direct action on the part of the petitioner, my lord, in this particular case. FIR at page 14 clearly reveals she himself has taken the poison and the husband.
Heard Dr. P.C. Majumdar, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. By order dated 7/11/2023, learned additional public prosecutor was requested to seek instructions from the investigating officer over telephone to find out as to whether the present petitioner appeared before the investigating officer and whether he had cooperated in investigation or not. Learned additional public prosecutor has submitted that he had received information from the investigating officer to the effect that the petitioner has already appeared before the investigating officer and his statement has been recorded by the investigating officer. He has also submitted that there are sufficient incriminating material against the present petitioner in the case diary. And earlier also there were instances when the victim was alive that the petitioner without the consent of the doctor, took the victim back home when she was admitted in Dibrugarh Medical College, where
Assam Medical College.
Assam Medical College.
Regarding
No,
that observation is
not Assam Medical College. You are opposing
yes, I am opposing.
on that ground the
And regarding that earlier one 498 case also registered against the president. Thereafter, my lord, settlement due to my lord,
and there
mutual
are sufficient
settlement.
materials in the case diary, and on that ground he opposes the grant of bail, opposes the making of interim anticipatory bail absolute in the case of the present petition. On the other hand, learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by order dated 24/8/2023, and in pursuant to the direction of this court, he has appeared before the investigating officer and has not violated any of the conditions imposed by the said interim order. Stop. I have heard the submissions made by learned counsel for both sides and have perused the case diary of Gilamara PS case number 44/23. Stop. It appears that the petitioner who was allowed to go on interim bail by order dated 24/8/23 has cooperated in the investigation and has complied with the directions of this court. It also appears that though there are incriminating material in the case diary, the investigation has fairly progressed, and therefore this court is of considered opinion that further custodial custodial detention of the present petitioner may not be necessary for fair completion of the investigation of the case if he cooperates in the investigation. Stop. In view of above, the interim anticipatory bail granted to the present petitioner by order dated 4/8/2023 is hereby made absolute with conditions number 1, 2, and 3 attached to the said order remaining intact. With above observation, this anticipatory bail application.
Item 54.
None appeal.
None appeal. We'll take it up after.
So bail hearing item 18, 19, and 20.
Well, in this case, in the earlier, on, I think 11/9/23, there is a direction to submit a report from the IOMLR. There is a CD and video clips, by showing the video clips, I was directed to send a report. Fortunately, what happened, some miscommunication there are, but that CD was not provided to the IO. He has taken back the CD, but that CD is with us. So today morning I talked with the IO. Some few days maybe allowed. 3 weeks. All are in interim.
You are on interim.
Yes.
Now, what was the direction?
Well, actually, what happened? There is a clash between two groups of people in a masjid, so there was a video recording, and that video recording was seized by the IO, and there's a direction, to see the video whether these petitioners were there involved
or not, to submit a report, in the last order.
No, before that.
Lordship, and for the information, that will video that will be in trial court, not this court.
There is already a direction, that report is not
Whether
available.
the pen drive was sent to FSL or not. That is the more important. Yeah.
No,
On the
whether
other
they
hand,
have
my lord,
cooperated
Two
after getting.
witnesses implicated.
We appeared, madam. We appeared.
All the,
APR.
at least two witnesses on the last occasion, two witnesses implicated the.
Are you opposing the bail or
Yes.
you are
He
opposing?
he is for the informant.
But you are also opposing that videography should not be looked in.
No, my lord, IO may give a report, my lord, because today I have talked with the IO, my lord.
No, I am on the
Videography, short.
mobile.
Yes.
No, I am not on that question. There was an allegation after clash that assault was made and somebody injured.
Injured, my lord. Previously.
There was a direction to the petitioners to appear before the IO.
My brother died.
Appear before the IO to go. Now that cooperation is there or not, whether their custodial detention is necessary. That is the main question at this stage.
That is there, my lord, but today, my
Because
lord.
we are not sitting on trial.
Yes.
Suppose there are materials, they will face trial. Question is whether to allow them
Yes.
to remain on bail or whether it will be dangerous.
My lord,
Or for any reason, it
my lord, class several people, my total 16 petitioner in both three petitions, my lord. So, my lord, 326 is there, my lord. So, my lord, it is difficult on my part also to say it like that. My lord, custodial interrogation is necessary because with the protection of the my lord, this my lord, bail, the my lord, statement, and without the protection are different, my lord.
how it is different.
No, my lord, with the protection.
What you do when there is no protection of bail.
No, my lord, with the my lord, protection, my lord, they may go and only to record their my lord, but
No, we may impose condition if you require their statement to be recorded at length.
my lord, today my prayer is my lord, as I have already talked with the my lord, at least 2-3 weeks, my lord, in the meantime. After that, my lord, may.
My lord, one submission, my lord, there is a cross FIR also. We will also file an FIR, my lord. My lord, they also approached this court, my lord. We have not objected to their bail. my lord.
They are also on bail.
Yes, my lord, they are on bail, my lord. We have not objected, my lord.
390. Simple in the, I don't know, that CD is not available with me and right now.
They approached this court, my lord. We have also not objected.
All three cases, similar orders.
Similar order.
Similar.
My lord.
On the simple injury.
No, earlier.
Earlier.
Heard Mr. N.J. Dutta, learned counsel for the, this is in
18, 19 and 20.
item number 18. Heard Mr. N.J. Dutta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Mr. M.A. Mondal, M. Ahmed, appearing for the informant. Thank you. Learned counsel for the learned additional public prosecutor submits that the video that the report of the investigating officer, which was called for by order dated 11/9/2023 in this court, by this court, could not be procured due to some communication gap and prays for some more time for producing the same. Why to, Mr. Parashar, why to keep this pending? Do you feel that
Yes.
something will come out?
Not, Yes, from January,
This case is pending since?
January,
No.
case is from January. And
If you want, we may impose additional condition, but they have cooperated. Stop. On the other hand, learned counsel for the petitioner submits that the petitioners were allowed to go on bail, interim bail by order dated 21/7/2023. And in pursuant to the direction of this court, the petitioners have appeared before the investigating officer and have cooperated in the investigation. Their statements are recorded.
Yes.
Learned additional public prosecutor has also verified it from the case diary and has submitted that the statement of present petitioners have already been recorded under section 161 CRPC. On the other hand, Mr. M. Ahmed learned counsel for the informant vehemently oppose the grant of bail to the present petitioner on the ground that the injury sustained by who died?
My brother.
In this case,
Arun Rashid.
the brother of the informant had died due to the assault by the present petitioner. But in the incident, and what other ground you are opposing, on what other?
Nurul Amin.
Petitioner. And there is, apart from material, any other ground that if they are released on bail?
They may threaten.
No, you have to make submission.
Rejected.
What difficulty would you face if they will? Are you apprehending that they will threaten you?
Tempering the
Yes. The learned counsel for the petitioner, learned counsel for the informant also submits that if the petitioners are released on bail at this stage, they may tamper with the evidence and may threaten the witnesses. Stop. I have considered the submissions made by learned counsel for both the sides and have perused is that it appears that the petitioners, after obtaining interim bail by order dated 21/7/23, have cooperated in the investigation and have complied with the directions of this court. And there is no material on record to suggest that they have violated any of the bail conditions. The apprehension of retaining witnesses as mentioned by learned counsel for the informant at this stage appears to be a mere apprehension. And therefore, this court is of the considered opinion that further custodial detention of the present petitioner may not be necessary if the present petitioner cooperates with the investigating officer and comply with the conditions of interim bail granted to them. Stop. In view of above, the interim anticipatory bail granted to the present petitioner by order dated 21/7/23 is hereby made absolute with condition that with following conditions. Number one, the petitioner shall not directly or indirectly make any threat, inducement or process or threat, inducement what was the 438, what it said, right? Promise, threat, inducement and promise to the informant slash victim slash any other person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer. The petitioner shall cooperate in the investigation. With above observation, this anticipatory bail application.
I'm deeply obliged.
The other,
My lord, item number 19, my lord.
19, there are 2%.
The interim order will be, my lord, 21/7/23.
other thing remaining same.
Same. 21/07/23 interim order, my lord. That is item number 19. And so
Item
far,
number 19, the interim order will be
21/07/23.
in item number 20,
And item number 20, it will be, my lord, 9/11/23.
then other will be
I'm deeply obliged, my lord.
James. খালি বহি কিন্তু বেছি বহি দুটা 15
21.
May I please your lordship? Lordship, the FIR lordship at page 14 lordship.
CD not received, Lord.
The husband of the informant committed suicide on 26 December 2022 lordship. After 27 days, the informant, the wife of the deceased, filed an FIR against the petitioner lordship. The petitioner is a married woman lordship, married lady having a son lordship who is studying graduate level course lordship. BSc.
No, whether after interim bail,
lordship.
have you appeared before the IO?
Lordship,
Whether you
we complied with the order lordship. So since the month February lordship, since February lordship, no learned
why
friend
CD has
could not obtain. See,
Lordship,
no reason have been.
we have sent the requisition, Lordship, 1, 2, 3, 4, 5, 6, 7 times, Lordship. I have to call IO, Lordship.
so in the month of February lordship, interim protection was given.
I may be very busy with other investigating.
So interim may be absolute lordship, a lady lordship.
Heard Mr.
Somebody-
S. K. Sarkar, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not been sent by the investigating officer. Learned additional public prosecutor also submits that diary was sent on 7 occasions, but the case diary has not been sent by the investigating officer. On the other hand, learned counsel for the petitioner has submitted that the petitioner, who is a lady, was allowed to go on bail, interim anticipatory bail by order dated 24/2/2023. And in pursuant to the directions of this court, she had appeared before the investigating officer and has cooperated in the investigation. So considering the fact that the prosecution side has failed to procure the case diary in spite of giving indulgence to them on repeated occasions. Also considering the fact that the petitioner has cooperated with the investigation and has complied with the directions of this court, the interim anticipatory bail granted to the present petitioner, to the above named petitioner, to the petitioner, namely Mathu Sharma, is hereby made absolute with the condition which was attached to the interim anticipatory bail order remaining intact. With this observation, with above observation, this anticipatory bail application is hereby disposed.
Highly appreciated.
Item 22.
Final reports submitted, Lord.
Third, Miss, what is your name? What is your name?
See, Dekha.
Third, Miss C. Dekha, Learned Counsel for the petitioner. Also heard Miss N. Das, Learned Additional Public Prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has submitted the final report. Why?
FR number
FR number-
33/23 dated 31/08/23.
In view of submission of final report in this case has this anticipatory bail application has become infructuous and accordingly disposed.
Item 23.
CD not received, Lordship. Interim is there, Lordship.
Third, Mr. A. Alam,
B. Islam.
B. Islam, Learned Counsel for the petitioner. Also heard Ms. N. Das, Learned Additional Public Prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this case be fixed again on
29
29
11.
11 for case diary. The interim order shall continue to the next.
24.
May I please-
Charge sheet submitted, Lordship. Charge sheet.
My lord, interim is there, madam.
Charge sheet is there.
And one section is there, 333, that is one session trial. Well, may I pray for absolute, my lord?
Interim is there.
Yes, ma'am.
Charge sheet submitted.
Otherwise, you appeared.
Well, yes, ma'am, we can.
No, you have appeared before the IO during
Yes,
investigation.
yes. Pursuant to the interim appeared before the IO and is that.
Then we are making this interim absolute.
Yes.
If you have cooperated.
Lordship.
You have to be very clear in your submission.
Lordship.
After obtaining interim bail, whether you appeared before the IO and whether you cooperated with the investigation.
Yes, well.
Okay.
Yes.
That yes has to be forceful.
Lordship.
Heard Mr. K. Rahman,
Yes.
Learned Counsel for the petitioner. Also heard Ms. N. Das, Learned Additional Public Prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, the investigating officer has laid the charge sheet, white charge sheet,
Charge sheet number 147/23 dated 30/07/23.
On the other hand, Mr. Rahman, Learned Counsel for the petitioner, submits that by order dated 12/4/2023, the petitioners were, how many petitioners are there?
Two petitioners, my lord.
The petitioners, namely, what is the name?
Shahjahan Ali and Abdul Hai, my lord.
Shah Jahan Ali and Abdul Hai were allowed to go on interim bail by this court. And in pursuant to the directions of this court, both the petitioners have appeared before the investigating officer and have cooperated in the investigation. Considering the submissions made by learned counsel for the petitioner, the interim anticipatory bail granted to the petitioners by order dated 12/4/2023 is hereby made absolute with condition number 2, 3, and 4 to the said order remaining intact. With this observation, this anticipatory bail.
Much of.
Item 26.
CD not received, Lordship.
You're on interim.
Yes, my lord. As per interim order, I appeared before the IO order. The thing is the
When will you produce the case diary?
On 27th, Lordship.
Heard Mr. K.U. Ahmed,
27th,
K.U. Ahmed, learned counsel for the petitioner.
28th.
Also heard Ms. N. Das, learned additional public prosecutor, who prays for another date for producing the case that the prayer is allowed. Let this case be fixed on 28/11 for case that the interim order shall continue till next day.
28.
May I please, your lordship?
CD received, Lordship.
My lord, your lordship granted us interim protection. Accordingly, we appeared and we have recorded our statement before the IO. But the FIR is at page 11. Your lordship will find.
No, before that, let us see whether you appeared or not.
Yes, Lordship.
They have
we have-
appeared.
we have
Appeared their statement
Statement
recorded.
recorded.
Yes,
Now, whether you want their custodial detention.
His Lordship, with materials are there against Lordship, petition number 2, 3, and 4, Lordship. 4 and 9, Lordship. Witnesses implicated petition number 3, 2, 3, 4, and 9.
2, 3, 4, and 9 also appeared.
Yes, sir, all appeared. My lord, I may be excused, but this is the order filed on session judge for one of the co-accused, my lord. After perusal, he said the custodial detention is not required, and 482, 382 has not been established. There is no material of 382. Then the other materials are 143, 147, 148, 325. All are valuable. And my lord, there is a quarrel inside the masjid after namaz. There is allegation that they have snatched away some money, my lord, which is but not usually 8,600.
No, who says that 382 is not applicable?
My lord, that order is there, in that order. Learned session judge has perused the CD and said there is no material of 382. In the statement of the complainant made before this IO, fact the snatching of the amount from him by the accused Yunus Ali and any other accused has not been, has not come. It is. It is a quarrel between the other members.
Heard Mr. S. C. Vishwas, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor, who has submitted the case diary of Barpeta PS case number 323/2023 and has submitted that though the statement of the present petitioners are recorded, have already been recorded by the investigating officer. However, against petitioner number 2, 3, 4, and 9, there are implicating materials in the case. And on that ground, she opposes the grant of bail to the present petitioner. On the other hand, Mr. S. C. Vishwas, learned counsel for the petitioners, have submitted that the petitioners were the present petitioners were granted bail, granted interim anticipatory bail by order dated 14/8/2023. And in pursuant to the directions of this court, all the petitioners have appeared before the investigating officer and have cooperated in the investigation. It is also submitted by learned counsel for the petitioner that that learned that the court of learned Sessions Judge Borpeta while granting the anticipatory bail to one of the co-accused, namely Zakir Hussain, has observed after perusal of the case diary that the no, this is not created to, it mentions only that against Zakir Hussain, no such.
Or any other fellow. Snatching the amount from him by the accused, Yunus Ali or any other accused. Yes.
That there is no, though that at that stage of the investigation, there is no material to implicate the accused persons under section 382 of the Indian Penal Code. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the case there. Though there are materials, incriminating materials against petitioner number 2, 3, 4, and 9 in the case diary. However, considering the fact that the present petitioners have complied with the order of this court and have cooperated in the investigation, and also considering the fact that their statements are already recorded by the investigating officer under section 161 of CRPC. This court is of considered opinion that their custodial detention may not be necessary for fair completion of the investigation of the case. Therefore, the interim anticipatory bail granted to the above named petitioners, name of the petitioner should be mentioned. Above named petitioners by order dated 14/8/2023 is thereby made absolute. With above author.
Lordship, in item number 29, Lordship, FSL report not received, Lordship, up to CD is required, Lordship.
Item number 20.
Lordship,
We
next one.
have to stop now.
Second half, in fact, I think farewell is there.
No, and also there are some fixed matters. So I'm at item 8, my lord. So it may be fixed on some other date because mine was a fixed item.
So far as item of 41 is concerned, my lordship wanted to know the provision and which
provision
401 you are. Is there.
Lordship, I
That may be a lot. 6 months.
But not now.
Date may be given Monday.
No, I'm offering a solution because if I start dictating, hearing each one of you, the recess period will be over.
No, my lordship would say, give a common order that leftover matters may be taken up on Tuesday.
Due to paucity of time, this matter could not be taken today. Let this matter be fixed on dash. This dash will be filled up by the
Dash will
court.
be filled up with.
There are certain interim orders.
The interim orders shall continue till next year.
Deeply obliged, my lord.